part heard appeal in the matter of the Geoffrey application of the Duke of Sussex and Secretary of State for the Department.
Good morning.
Good morning. I hope you should have in hard copy, and I hope it's reached you electronically. I'll be sent direct to the clerk.
So what's supposed to have reached me?
There's a document entitled Summary of Respondents' Core Open Submissions.
Yes, thank you. Yep. Lovely, thank you.
Do you have that electronically?
Yes.
I'm rather hoping that does what my lord invited me to do yesterday, but it does it for each of the 4 heads that I'm going to address you under. And it gives you the basic propositions, which I will develop if I may order, but at least it will save you taking down.
Can this be provided openly to others?
Yes.
Good. Well, then it may be provided to the press. Thank you.
My lords, as you'll recall, we were yesterday on the interpretation of the 2017 RAVEC.
Now, just before I did ask
Yes.
Ms. Fatima if she could put her points in.
She's done that too.
Have you done that?
My lord, yes. I believe it was sent to you yesterday evening.
Unfortunately, it hasn't got to me yet, but I think by saying in open court that it hasn't got to me, it'll get to me very soon.
We can certainly try our best to resend it.
Thank you. If it could be resent. Thank you, Sir James.
As I was saying, we were on interpretation of the 2017 terms of reference.
Yes.
And when we finished yesterday, I was about to make the submissions, the 5 submissions, and you see the basic 5 flagged in the summary document. Can I just invite you to cast an eye down them, and then I will develop each of them if I may. So far as the first is concerned, the terms of reference are internal guidance to assist in decision making by RAVEC and setting out the key divisions of role between the various different bodies involved in a highly specialised context with experts, as it were, running the show. They are, as you know, internal. I think they were designed, as the evidence demonstrates, to be shared, well, they of course have been shared by way of disclosure in this litigation. And indeed, that he hadn't seen them, if Appellant hadn't seen them, was part of the now gone procedural fairness complaint that was rejected by the judge and isn't renewed here. But for this purpose, the point is that this is internal guidance to those involved in the decision making, very much with that focus. It isn't public-facing guidance. I'm not making a great song and dance about publication or not publication. Of course, there are certain circumstances where the public don't see it, where the guidance can still be a policy of the requisite kind. But this one definitely wasn't public-facing guidance.
But this is guidance of a kind that ought to be followed if there's not a good reason for following it, you would say.
Well, my lord, what we're on at the moment is the pure issue of interpretation. Does it set immutable rules? We'll come to good reason in due course and the standard and the rest of it, and whether there was good reason.
But you're making a lot about the type of guidance. That's
Yes.
why I'm asking the question.
I'm making a lot about the type of guidance as a part of the context in which you interpret this document.
Okay.
And it goes, as it were, to lightness of touch, if I can summarise it that way, rather than heavy-handed, rigid rules. I was drawing that comparison. That's the purpose of it. It wasn't, as it were, like immigration guidance or policy, which is designed to deal with a big run-through of cases where the fundamental importance of having that species of guidance, that type of guidance, is to ensure across a wide range of factually very disparate cases, consistency of decision-making, and people can see and make judgments about how they act and react on the basis of what they see in that immigration guidance. Those features are absent here. It isn't therefore remotely akin, we submit, to statutory policy controlling those sorts of large flows, for example, through the immigration system and the immigration guidance and so on that you are all very well aware of. It's much more fluid than that. That's its context, that's its basic nature. And we submit that the judge was right to recognise that basic nature as part of this exercise of interpretation, still under this first main submission, as he did at paragraph 156 in the judgment. In a nutshell, the TOR, the terms of reference, are for the use of experts, and by experts I include all of those in the various bodies that are referred to, RMB, RAVEC, Met Police, anyone else who's involved in the decision making and so on. They are for the use of experts in making the various judgments that are called for by the context. That's the first main submission that you have in the summary. The second of them, I read that briefly just so that those who are listening can follow the argument. The second submission is that there is nothing to suggest that the terms of reference are designed to make provision that must be followed and cannot be departed from, or have exceptions created, or that the bespoke process that is judged better to serve the ends of the decision making, applying the guiding principles in the TOR, cannot be done. There's nothing to suggest, to put it a slightly different way, that they were intended to operate rigidly, inflexibly, and without the ability to tailor decision making and its processes to the facts of the case under consideration. And of course, as you're very well aware, policies more generally may often be framed in apparently unqualified terms, and all will recall some of them in the Good Law Project case, but will still need in fact to be designed, and are in fact designed and intended, in a particular context to admit of exceptions and qualifications. Sometimes that is because it is necessary in public law terms to ensure that whatever policy or guidance you put out doesn't fetter your discretion. That would be extremely problematic if you were operating under a statutory regime, as you know. Here, we're not operating under that sort of regime. It makes the position a fortiori. We're operating under royal prerogative, where there aren't, as it were, those statutory framework controls.
Well, can I just ask you this? We said at paragraph 59 of the Good Law Project case, we do not find there is a duty to comply with the 8 policies. You remember the 8 policies about WhatsApp messages and so on. Is there a duty here on RAVEC to comply with this terms of reference?
My Lord, the answer to that question is yes, as long as you understand what it means and what it's intended to mean. That's why I start with interpretation. We're not running a species of non-justiciability argument.
Yes.
If I may still on intention in the second submission, that there are good reasons of principle, therefore, against it being designed in a hard-edged way rather than a fluid and flexible way. The principle is the one I've described: need to avoid fettering, need to leave it open, must apply a fortiori to royal prerogative because of the absence of a statutory framework, but also good reasons of practice, because to take any other approach would fall straight into 2 problems. One of them is the policy, not law distinction, and the second of them is to adopt what we respectfully submit with respect the judge was correct to characterise, see for example paragraph 178, as the appellant's, quote, mechanistic and overly literal approach to the 2017 TOR. Still on the same theme and the final point under this second submission, it is not surprising, we submit, that documents such as this, such as the 2017 TOR, do not specifically address all cases. They don't address unusual cases like this one. And that illustrates a broader point, which is that it simply isn't helpful to approach the language of what is in the TOR as if they were intended to do that. And it makes little specific sense to complain that the terms of reference don't provide for the sort of bespoke process adopted for the appellant. Almost by definition, a policy won't provide for a bespoke process outside its ordinary run of operation. But a policy should not, in principle, we submit, be interpreted as precluding the need to deal with those cases if they fall through the run of cases that go through the system, as this one does. And unsurprisingly, perhaps, no complaint is advanced by the appellant that RAVEC is continuing to consider his case. He hasn't fallen outside of this process at all. He's considering his case and continues to do so, notwithstanding that there is nothing in the terms of reference that directly or expressly allows for that. But that's just the flip side. That's a reflection of the obvious need for flexibility and pragmatism and a high-level framework document such as the TOR, providing the sort of guidance it does. So that's the second submission. The third submission is perhaps the most important. The most important feature of the context here as integral to correct interpretation. You have this summarised on page 1 of the short document I handed up. The most important feature of the context here as integral to correct interpretation is the nature of the exercise that those acting under the terms of reference are undertaking. And we submit, just to develop that a little bit if I may, we submit that a reasonable person, and no one's quibbling with the idea that it's the reasonable person that we're dealing with, see Raisi and other very well-known cases, the reasonable person would clearly understand that the core objective of those functions, i.e. the functions of those with responsibility for making decisions under this process, is to make nuanced judgments about security protection, bringing all of their expertise and experience to bear, including, I would add, making decisions about unusual cases and what process should most appropriately be followed for the run of cases going through that system. The core objective that I've just described is not consistent, we submit, with the sort of mandatory, rigid, rules-based approach that is being suggested as the intended interpretation here. And at paragraph 158 in the judgment, the judge recognised that the subject matter at issue and the expertise and constitutional responsibilities of the relevant decision makers were relevant to the task of construing how this policy was meant to work, how it was intended to operate, and the nature and the scope of the things that it was intended to permit. He also found at paragraph 175 and 178 that the terms of reference fall to be read in a more nuanced way by reference to, as he put it, the significant knowledge and expertise in the highly specialist area with which we are concerned of our witnesses, including the unremarkable proposition at 175 that, as he put it, they can be taken to have a thorough understanding of the RAVEC terms of reference, a point which accords with the principles we looked at yesterday from Hopkins Holmes. As you will recall, I won't go back to that. So this context, including this objective, is, we submit, entirely unlike the sort of cases and the sort of policy that the courts were considering in other cases, including in particular the immigration context, which forms a large part of my learned friend's cases relied upon. The judge correctly noted at 159 of the judgment the absence of any statutory context. This is an aspect of the royal prerogative. There is no statutory framework. But it's not just that technical legal distinction, as it were. It is the very context that I've just described which distinguishes and renders inapplicable and unanalogous cases from those very different contexts. That's the third proposition.
You're going to tell us how they're inapplicable. In other words, which parts are inapplicable and which parts are applicable from the immigration cases that have been cited on the other side.
My Lord, I am, and I'm going to come to that particularly when we come to consider good reason, what does it mean, how does it work, and all of that. But in terms of this exercise of interpretation...
No, I understand it's not here.
It's not here, but I will come back to it, I promise. The Munjaz line and all of that.
Yes.
Come to that, of course. Fourth proposition, in such a context, it isn't just, as it were, flexibility isn't just neutral. There are positive advantages in not having the terms of reference as rigid rules, but rather as guiding principles to be applied flexibly to the circumstances of particular cases. The prerequisites, to go back to the very basics, the prerequisites for considering inclusion within, as it were, those cases that RAVEC considers are set out in Mr. Hitgrave's first statement at paragraph 25, supplemental bundle, page 85, all of which is confidential, so I don't...
But the problem slightly with that submission is that actually over time the terms of reference and the evaluation criteria have become more prescriptive, not less.
Well, my lord, they may have become in certain respects more detailed. My submission is that they haven't become more prescriptive, if by that you mean they've gone closer to being rigid rules than being flexible guidance.
They do seem to have much more content as time progresses. We saw in 2008 there's one side of a sheet of paper written in rather mercurial language, and now there's pages and pages of things.
My lord, none of that I deny. My submission is that it doesn't affect the essential nature of them.
Okay.
It simply provides more detail, not an alteration of nature.
Right.
My submission under this fourth main point is that each case does fall to be considered and should fall to be considered, both procedurally and substantively, on its merits, in accordance with the particular circumstances of the case. And there's nothing to support a case that bound RAVEC through the terms of reference into either identical processes or still less identical outcomes in relation to particular fact patterns that might appear. There's no dispute on the evidence. I made the point clear yesterday. I confirm it. There's no dispute at all that, for example, RMB risk analysis is indeed the usual approach in the usual case, and that the role of RMB may be thoroughly important in the usual case. But there was nothing about the appellant's announcement in January of 2020 that he was to step back from his role in the royal family and live most of the time, at least abroad, that was usual. It was, to use the Latin, I know we're not allowed to, but to use the Latin, it was inherently sui generis. In other words, it was a category of its own. It was a unique set of circumstances. That's the fourth proposition. The fifth proposition focuses on the particular language, which my learned friend's submissions all at least drifted a little way away from, but I do respectfully submit on the skeleton at least form the linchpin of the argument. In such a context, will, which is the word used in paragraph 20, as you'll recall, of the 2017 TOR, will, not maybe or can, does not even suggest that it was intended to create an obligation of some kind. You'll recall that in paragraph 20 of the 2017 TOR, the will word was all under the heading of key tasks. So it was simply describing a task or function, rather than being in the form of something that creates mandatory obligations. And the judge was right, we submit, at 162 of the judgment, to conclude that even at its highest, paragraph 20 could not be applied to all or any individuals who demanded protective security under the system, precisely because there were value-laden judgments as to who should be treated as falling within the RAVEC cohort, to what extent, if you do fall within, what is the most appropriate procedure, what is the most appropriate outcome in terms of protective security. So all the value judgments in question to be made as to whether a person fell within, and if so, what security should be provided, would in fact be informed by an RMB assessment. That's the question. Would it be informed by an RMB assessment in circumstances of the exceptionality of the appellant's case? And we submit it isn't appropriate to refer to RAVEC, as it were, exercising a jurisdiction in a strict sense. What it does is to simply make discretionary, value-laden judgments as to the appropriate and proportionate use of public funds to provide protective security to royals and VIPs where that's justified in the public interest. That's the essential nature. And so we submit that the judge was right to emphasise, as he did repeatedly, that the terms of reference require those value judgments to be made, both procedurally and substantively. And it might be thought, but all the more so, those points are all the more forceful, given the description, accurate as we submit it to be, of the essential nature of the RMB process. Can I just invite you to go back to the judge's judgment at 229, paragraph 229. Starts at page 158. And his description of it, accepting a submission that I've made, is at the top of page 159. It is an analytical tool. Accordingly, given RAVEC concluded that a better tool was available in the form of the process described in the letter of the 28th of February with no procedural unfairness, and so on. It is ultimately the RMB process an analytical tool that informs, or may inform, those value judgments. And once that is evident, it's equally evident that whether the analytical tool is in fact useful and the most appropriate process to go down, and certainly in relation to any suggestion that it was intended as a matter of interpretation to be mandatory in all cases, becomes untenable. It's simply a tool in considering the issues as to whether someone should have protective security under RAVEC, and if so, in what form. And the question that has to be considered by the decision makers is whether or not that is the most appropriate way of doing things. Is that an analytical tool which they wish to reach for in the particular circumstances of the case? We note finally in relation to this fifth point that on the evidence it's perfectly clear that RAVEC did not in fact apply or operate the terms of reference as if they set a whole bunch of hard-edged rules, but did treat them as providing guidance to the sort of decision-making, myriad different types of decision-making they'd have to make in relation to the cases which they had to consider. So that's what we say about interpretation. I turn then, if I may, to the second argument, and I'm going to take this in two parts. The first, the respondent's notice, and the second, the way in which the challenge is made on this appeal.
I mean, you, despite all that, which I understand, you accept, I think, that the proper interpretation of the terms of reference is that an RMB analysis will be done before a decision is taken. That's what it says.
In the usual run of cases, what we're arguing about on interpretation is whether that's an immutable rule that has to be followed in all cases, including this one.
Implied into it is in the usual run of cases.
Yeah. That's the sense of the interpretation. That's what divides the parties. A learned friend says, as a matter of interpretation, RAVEC has no option. It's bound by the wire on the cage. And we say it's more elastic than that and plainly intended to be so.
And do you say, as I think I put to Ms. Fatima, that your case was, well, this is not, this kind of exceptional case is not mentioned in the terms of reference?
Well, I do, and I made that point, I hope, clearly during the submissions.
Yes.
But it's a very important point for a variety of different reasons. From the perspective of interpretation and the debate that I've just described between the parties, it's important for this very specific reason, which is that it illustrates that they're not intended to cover all fact patterns going through the process. If they were intended to provide, as it were, a complete and hard-edged code, we couldn't do anything.
Yeah, okay.
That's the point for interpreting purposes. We'll come back to the significance of it on other stages of the argument, but thank you for the reminder. I hope I've made that point. My Lords, I said that I was going to take the second argument in two parts. As you'll recall, the appellant's second appeal argument, as I described it yesterday, is that when considering the legal standard to be applied to the good reason to depart test, the judge was wrong to show respect, says the appellant, to the primary decision maker, to recognise that there was no statutory context and place weight on that, and to draw on the analogy of demicide duty. But essentially it's a submission that says wrong to accord respect to the expertise and experience and democratic accountability and so on of the primary decision maker. That's the appellant's case, but there are logically at this stage two different points, and the first logically is the respondent's notice point, which is if you get to this stage and you're looking at the reasons to depart and the wrong, whether there's good reason to depart and so on.
I don't want to be difficult or take you out of your course, but I do want to unburden myself of a thought.
Yes.
I know the court shouldn't have thoughts, but I've had one.
Better to unburden sooner rather than later.
I'd probably say that we don't. I want to know what your submission is and Ms. Fatima's submission. It seems to me at the moment that it might be the case that we are asking the wrong question, because what I would suggest is that if there is, let's assume, a liability for this policy, for failing to follow this policy, and that's obviously subject to everything we've said and its true meaning and so on, the question is whether the authority has failed to follow the policy as interpreted by the court without good reason, and that it might be said that the question is not to be split up in the way that both sides seem to want to split it up into two questions: whether the authority has failed to follow the policy as interpreted by the court, and secondly, whether there was in fact a good reason, which is what leads you to make your respondent's notice point about the second question. But if you ask the question, which seems to me to be actually the question, has the authority failed to follow the policy without a good reason, then that answers both sides of it, and you don't get into irrationality or not, because that has all the nuance that you need, because you will give whatever deference is due on a sliding scale depending on the kind of decision maker, and you'll look at the failure within the context of the interpretation by the court. And I was struggling with this in putting to Ms. Fatima yesterday that she was breaking this all down into too many boxes, and that public law is not about boxes. It's about seeing whether something has gone seriously wrong in the administration of government, and if it has, of course, there will be liability. But it's not about having some sort of flow chart of decision making where you ask question one, and if question one's yes, you go to question two, and question three, and question four, and you come out with an answer which may be totally illogical. And this business of breaking down good reason and failure to follow the policy into two separate watertight compartments, I balked at that, and I wondered what your submissions were about whether...
My Lord, I have, if I'm allowed to have sympathy with that intervention from the court, I have some sympathy with that. And of course you will appreciate...
I'm sure I need sympathy.
Yeah, I have particular sympathy, if I'm still allowed to use that term.
Yes.
I have particular sympathy with the idea that public law is not about boxes, and it asks sensible questions in context with a view to seeing whether something has gone seriously wrong. So I don't mind that. The difficulty perhaps is that one does sometimes have to judge what it is at the very base level a policy means. And that does relatively frequently arise as a matter of public law. That's why the line of authority based in RAISI is set as it is. So you have to start with what the policy is requiring you to do on its face. That is a logically prior question. So although there may be some capacity to merge that principle recognised in public law.
No, I think you're missing my point.
Well, then I'm sorry.
I'm not suggesting that Baisi and what the policy is not a separate question.
Right.
What I'm suggesting is that when you come to compliance with the policy, the question is not just have you failed to comply with the policy, but have you failed to comply with it without a good reason?
Well, my lord, I think we both agree that that is the right question.
Yes, but it's only one question.
And I think we both agree that it's only one
Good.
question.
But then that's
But
absolutely
you
fine.
still have to answer. I'm afraid there is a but. I'm sorry to push back.
But you don't say it's a rationality question, the failure to comply question.
I don't say that the failure to comply question is a rationality question. I say the judgment of whether or not there is good reason to depart if it means a particular thing.
But then you do break it down into two.
Then I do say that as a matter of public law, when you are assessing good reason, there is a straightforward choice, which is not an unfamiliar choice to public law, particularly when you take into account human rights cases, which is a particular issue for the court to determine for itself, or is the relevant issue an issue which is for the primary constitutional decision maker to take, subject only to public law control through rationality? That is a very well recognised question that arises across the sphere. I mean, to take the Human Rights Act example, my lord will recall that at the heart of one of the issues, at least, in the Rwandan appeal, was that question as to whether or not the divisional court had got themselves in a bit of a muddle about what the nature of the approach was. And the muddling question was, had they decided, in effect, that they should be asking whether the Secretary of State was entitled to reach certain views which smacked of rationality, or was the correct approach, as my lord and the Supreme Court ultimately found, that because this was a human rights issue, it was well established that this was a matter for the court to determine, ultimately, as the decision maker. And I do submit that that type of issue does arise here and hasn't yet been determined. In other words, when you're assessing the good reason, it may ultimately be a very, very fine dividing line, because we say that even if it's good reason for the court, there's still a question about how the court goes about doing that, and respect is integral to the how question. So there may be a very fine line between these two, but at least in principle there is a distinction between an approach that says good reason is a matter of rational judgment for the Secretary of State, on the one hand, and good reason is a matter of objective decision making for the court, and we would add brackets, applying the correct approach to that question, which involves according proper respect if there is expertise in play. So that's why I've divided it in this way. My lord, can I mull on that as I make the submissions? I ought to give you the submissions anyway. So
yes, no, give me the submissions. I think a bit of mulling is due, because to accept that you ask the question in an incomplete question, which is have you failed to comply with the policy,
does risk muddling everything up.
Yes, because actually the whole thing is to do, the deference question is on a scale.
Yeah.
Depends on what
bit of it you're talking about.
Yes,
No,
and you can't really answer have you failed to comply, because you say at one end of the spectrum, well, they didn't really fail to comply because the policy may have said you should have an RMB, but it didn't address this type of case. At the other end, they say this is a black line policy. Yeah. You have to, but you can't answer the question of who's right without considering
who's applying it and what
who's applying it and what deference you give, and who understands the policy and all the stuff. And so, in the end, if you put it into watertight boxes, you are prone, I think, in public law to get the wrong answer. Now, everybody, that's at the moment where I am, and I'm not sure it benefits either side. Actually, I think it's just a better way of looking at it. I think it's a better analytical approach. That's what I'm putting to you, and if I'm wrong, of course I'll be correct.
No, my lord, you're not getting, as it were, total pushback. I just wanted to
take time to
see if there were facets that needed to be thought about.
Because I don't, this is an important case. We don't want to get it wrong.
No.
And we don't want to knee-jerk. It's, it's something where it does actually raise. And the only point which is new, I mean, the rest of it is factual, perhaps a normal public law, but this is a new point, I think, question of the test to good reason. Only Lady Hale had something to say about that in the Court of Appeal, and she wasn't upheld in the Supreme Court.
Yeah. Well, yes. But listen,
Okay, on you go, I'll shut up.
Can I, for the moment, as it were, because that's how I've structured the submissions,
of course,
with recognition that the issues may bleed, you may need a composite approach, it may at least help to have the way in which the arguments, if you did split it out, worked before you, so you can see whether there is, and if so, to what extent that overlap.
I'm not going to do what some judges do, which is think their idea is the only idea in town. You carry on, make your submissions as you planned, and just have a think and give me your considered view at the end of it.
Thank you. Thank you. So on the respondent's notice point, if we're there, if this is the right way of looking at it, if it requires a separate analysis, we submit that this is a question, whether there's a good reason to depart, is a question for the rational judgment of the authority here exercising its prerogative power. The basic principles, before I come to the submissions that you have on page 2, which I will develop again in the way that I did with the first heading. We're now on page 2, at the top, good reason, rationality, standard. We've got the 6 submissions there. But just before getting there, clear the ground. The basic principles are well established. Policies are not law. Policies may have legal effects. See Good Law Project, my Lord's Judgment, paragraph 63, Authorities Bundle, page 996. Those legal effects may include the principle that an individual may have a public law right to have his case considered under whatever policy has been adopted. And that is Mandalia, you saw yesterday, para 31, Lumba, para 26, per Lord Dyson, Authorities Bundle 323. However, having regard to the wide array of contexts in which policies of various kinds are adopted, policies, guidance, what's in a name, it is not the case that every policy or provision within a policy will attract that right. That was the public law development, as it were, that recognition that flowed out of the Good Law Project case, paras 55 to 56, Authorities Bundle, page 994. But none of those basic principles directly at least answers the question as to the standard that will be applied in assessing whether the decision maker lawfully decided that it did have good reason to depart from the policy. And that's the point at which I jump into the 6 submissions in the summary document. And the first of them is that from first principle, whether or not an authority has a good reason is to be assessed by reference to rationality, because the choice to depart from a policy is the exercise of a discretion. And the public law principle is that exercises of discretion are, as to their substance, subject only to the high hurdle of rationality. And the entitlement, just to develop that a bit, the entitlement of a public authority to depart from a policy for good reason is both a reflection that a policy is not law, and not to be interpreted as if it is, and that it will generally be the case that a policy must not operate as a fetter in the exercise of the statutory power in question, which is the most common form of discretion that one has. So they positively cannot, as a matter of public law, shut the door, whatever the terms of the policy, to the possibility of an exception. And they therefore have to they will therefore have to decide and consider whether or not to make an exception. And that's a classic exercise of discretion. And it's a classic exercise of discretion in that public law sense, because the constitutional underpinning is the same. It is the executive and not the court which has the function of deciding whether it's appropriate to apply the policy or to do something different, to make an exception, to react to an unusual set of circumstances in a particular way. And it's the executive, not the court, which is accountable for that decision making. So that's the first submission. The second builds on it, which is that the decision whether or not to depart from a policy is a classic exercise of discretion, not materially dissimilar from the exercise of discretion involved in how to apply the terms of a policy. So application of the policy in a particular case is a matter of discretion. And the latter is well established to attract the rationality standard. We know that, for example, if you take up electronically or physically the authorities bundle and go to page 898, tab 22, and after Lord Reed in the Begum case, and 898, you see para 124 by the letter C. I just invite you to read that, particularly that second half. On the other hand, the question of how the policy applies to the facts of a particular case is generally treated as a matter for the authority, subject to Wednesbury. That is most obviously the correct approach, whereas in the present case, the application of policy expressly depends on the primary decision-maker's exercise of judgment. If she's satisfied that doing so would expose individuals to real risk, is the example given. And can I invite you also, in that respect, to have a look at Lord Bingham in the Mullen case, that's paragraph 12. That's in Authorities Bundle 1, tab 4. Page 129. And you'll see in particular the fourth point that he makes in paragraph 12, which goes over the page to 130. This is about paying out under ex gratia compensation scheme, so royal prerogative again, but he says at second line on page 130, I consider that the Secretary of State must enjoy some latitude in the administration of the ex gratia scheme so long as he acts fairly, rationally, consistently in a manner that does not defeat substantive legitimate expectations. His decision has not been shown to offend any of those rules. And we submit that that approach, those principles, apply all the more so where the nature of the judgment in question is not only a fine one, but necessarily involves the potential for predictive evaluation and national security in a context such as this. So that's the second submission. The third submission is that the judge was right at 159 to note that the point in question, should there be a departure, if that's the right way of looking at it, should there be a departure from the terms of reference in the context of the RMB, in other words, we don't need an RMB process prior to the decision in question, that question was very, very close to a complaint of a failure to make adequate investigation or inquiry on a Thameside basis. Indeed, that was part of the way in which the case was put below. Thameside, as you know, requires the Secretary of State or the authority, public authority in certain circumstances, to conduct reasonable investigations to inform themselves prior to making a decision. And that's the nub of the allegation here in relation to the RMB. They didn't do the inquiry or didn't call for the inquiry that was there and was necessary. That is pure Thameside. And the significance of that for present purposes of course, it is now in the context of the policy, but the essential nature is a Thameside nature. And as we know, a Thameside complaint does allow the decision maker the leeway that the rationality standard accords. And you have, in relation to Thameside, for that principle, that it's subject to and controlled only by rationality, you have the Court of Appeal, I think it was Lord Justice Singh and Justice Coulson, I can't remember the third member, but the Court of Appeal in Balajigari, in a very well-known case, paragraph 70, don't invite you to turn it up, simply establishes that Thameside is a matter of rationality challenge only. Balajigari, paragraph 70, Authorities Bundle, tab 19, page 740. The fourth submission refers you to an authority that was handed down after the judgment by the Lady Chief Justice in a case called the Secretary of State for Justice and Snowden. And you have that, if you would, in Authorities, Bundle 2, tab 29, page 1096. In a different context, of course. This was a case involving, as you see from the head note, it was a case involving the parole board and the Secretary of State and the intersection of their powers and responsibilities. And under the relevant statutory scheme, the Secretary of State in certain circumstances, and here the context was transfer to open conditions, the Secretary of State could ask the parole board for advice. There are obviously certain circumstances in which the parole board can give, as it were, directions to the Secretary of State, can produce judgments that the Secretary of State is bound by, in effect. This wasn't such a context. This was a context in which advice was sought from the parole board, and the question there was, what are the circumstances and what are the principles that govern the possibility that the Secretary of State will get advice from the parole board and not like it? In what circumstances could the Secretary of State depart? And there'd been a whole raft of first instance decisions building on the Bradley line of authority, in effect saying you need good reason or you need compelling reason for a departure from the parole board's advice. And in essence, what the Lady Chief and the President of the KBD and William Davis, or Justice William Davis, decided was that the position was governed purely by rationality. In other words, the Secretary of State could simply disagree with the parole board's advice, and whether or not that was unlawful was simply a question of rationality without any supervening imposed test or heightened test, as it were. And you get that, if I can just refer you to the paragraphs, you get that in particular from paragraph 33 on page 1109. Can I invite you to read 33 down to the end of 37? It's a little bit longer than the sideline passage, but page 1109, 33 to the end of 37, if you would.
Yeah.
And then the disposition of the case, in effect, at 44 in particular, 44 and 45, perhaps, if I can just invite you to read those.
Sorry, just give me the paragraphs.
44 to 45, my lord, so sorry.
Thank you.
4 ones in a row, 1, 1, 1, 1.
Thank you very much.
I mean, 44 gives some support to the point I was making.
My lord, I had spotted that. It does, but you'll see why I take you to this authority. We submit that there is, of course, it's a different context, but we submit that there are some parallels, as it were. Translate that kind of reasoning into our situation. RAVEC will take account of its terms of reference and the role of the RMB and the way in which it's usually very useful and so on, of which it can be assumed to be very well aware, but it can identify and is entitled to identify reasons to depart from them in a particular case, which it may for itself consider to be both good reason and sufficient reason. But in reviewing the lawfulness of that decision, the court's role is to assess the rationality of the decision. Of course, that exercise will no doubt include consideration of whether or not RAVEC has taken account of the rationale for generally seeking RMB's advice and so on, as reflected in the TOR. But that doesn't involve the court substituting its own view as to the reasons and whether they were good or sufficient or not. It's a rationality test, in large part because of the fact that in that context, under that statutory scheme as here, the primary constitutional decision maker and the person who has to judge all of these things is the Secretary of State, or here RAVEC. And any other approach would therefore require the court to substitute its own judgment on the merits of that decision for the constitutionally accountable and institutionally competent decision maker.
I can't help thinking that all of this assumes that there is some binary decision as to compliance with the policy, so that it assumes that the interpretation of the policy is clear, and it is clear that there has been non-compliance, and then you move to the question of good reason. But actually all of the questions, namely the interpretation,
may feed back into a lack of clarity at that point.
And the good reason are interconnected.
Yes, my lord, I totally accept that.
And you cannot just say, I'm paying no deference to the decision maker in some circumstances, at any of those 3 stages, but how much will be on a sliding scale. The whole thing's on a sliding scale.
Yeah,
that's what public law's about.
Yeah. Although none of those basic propositions we have any disagreement with at all. And can I take it very, very quickly and give you the last 2 points super quickly, so as not to try the court's patience any longer?
It's a very patient court.
I've noticed. My lord, the 5th proposition, as set out in the summary document, is probably doesn't require much development. And we thoroughly endorse the point that is made by my lord and the position here about the overlap between the various boxes that we're considering analytically. I mean, if one takes this issue, is it for the court to decide good reason, or is it a matter of rationality controlling the decision of the primary decision maker, versus it's for the court, but you have to accord lots of respect because that's entirely obvious for reasons I'll come to in a moment, and I've already flagged. That distinction becomes very, very fine, and it becomes particularly fine once one recognises that rationality itself exists on a spectrum. And so the intervention that rationality permits as a matter of public law is not itself fixed or immutable. It is reactive to context. So there are certain circumstances which are particularly anxious, where rationality itself as a principle will attract greater and more intense scrutiny. So that's the 5th proposition. The sixth proposition is that Munjaz does not provide binding authority rejecting rationality. I want to make three short points by way of development of that. You'll recall the bits my learned friend took you from yesterday. I didn't get back to them in the interest of time, particularly Lady Hale. But the submissions are these. The statements of principle in Munjaz, and in Lady Hale's judgment in Munjaz particularly, are consistent, we submit, with either approach. In other words, either for the court or rationality. She is simply making the point that intensity of review varies depending on subject matter. And that's something which is a good point when applied to rationality. It's very familiar under rationality that intensity of review sits on a spectrum, as I've indicated. In that case, it's to be borne in mind. In other words, in Munjaz, the courts were dealing with a very different argument, and the argument was that there could be a decision to depart from the relevant policy for good reason or none at all. But you weren't really in a territory review at all. It was more like a non-justiciability argument. Unsurprisingly, the court rejected that, but it is neutral as to the debate that we are having between rationality on the one hand and good reason giving leeway or respect on the other. It's also, for good measure, dealing with a very different context, a very anxious context involving the detention of mentally vulnerable persons, their patients, and its own particular statutory context. I do want to emphasise that, because this shouldn't be sidetracked into a question as to whether or not there was an obligation of some kind created by the statutory regime. There wasn't there, and no one's suggesting that there was. It doesn't turn on whether or not there's a statutory obligation of some kind. The relevance of the statutory context is that it may make clear, absent an obligation, just how important it is that there should be policy, there should be guidance issued under the statute, which should guide decision-making across a run of very different cases that will have to be applied as consistently as possible, for all sorts of obvious and good reasons, particularly when one's dealing with a subject as difficult and as anxious as the detention of those with mental difficulty or incapacity. So those are the 6 points we make about rationality versus for the court. In any event, and this is the second part of it, as it were, this is the ground of appeal, even if the judge rejected those submissions, as you'll recall in the judgment, he said, no, it's a matter for me to decide, but then the ground of appeal arises, even if the judge is right on the basic approach, and good reason is for the court, it is still, we submit, appropriate to accord respect to the decision maker in a context such as this, and what they thought was a good reason in effect. And that's the subject of the submissions that I've sought to pull together at the bottom of page 2. You see the title, If Good Reason is for the Court Still Appropriate to Accord Respect to the Decision Maker in a context such as this. And I've given you the 4 submissions that we make there. I just wanted to develop them briefly, if I may. We've addressed this issue in our skeleton at 29 to 31, and we submit ultimately that the fineness of the distinction between this approach and rationality is recognised correctly by the judge, and it may be that this goes to my Lord Master of the Rolls' points about breaking down the boxes, but as he concluded at 158 of the judgment, it doesn't matter which one is right, because you've still got the same outcome. It leads inexorably to the same outcome, whichever way you look at it. The particular point here, however, is that he was also right in 158 to recognise that the expertise and constitutional responsibilities of the relevant decision makers was relevant to whether there was a good reason. And in particular, he was right to hold that the judge must not substitute its own value judgment so as to violate the principle of separation of powers. Our context, I emphasise, has almost every feature that has been identified as leading the courts to respect and accord the widest respect to decision-making of the primary constitutional decision-maker in a context such as this. And just to give you 4 or 5 points to make that good. RAVEC, as the delegate of the Secretary of State for the Home Department, is the democratically accountable decision maker. If the wrong decision is made, echoing that famous postscript from Lord Hoffman in the Raymond case, after the Twin Towers had been attacked, as you will recall, if the wrong decision is made, the fallout from that comes to the Secretary of State. She is the democratically accountable decision maker, and RAVEC is operating for her. RAVEC is able to draw on expertise and is itself expert and experienced in a thoroughly important way. So expertise is uniquely available to the executive in this context. RAVEC's judgments are made in the context of and about security, including national security, as the judge rightly accepted at 157. It has to consider and weigh the impacts on the public interest of the consequences of, for example, an attack. And that isn't merely a predictive judgment, itself a ground for respect in its own right. You'll recall para 32, which I'm going to come to, of Lord Carlisle, emphasising that the predictive judgment was one of the bases on which you record respect to judgments of the executive in this sort of context. But the subject matter is about as far from something that could attract empirical proof or a right or wrong answer as one could imagine. And the recognition of the executive's competence and accountability is underscored, whereas here the decision is made personally by the chairs of RAVEC with the intimate involvement of the chair of the RMB at the time, who are highly experienced and expert in these sorts of issues and what is and is not the most appropriate way of going about the decision making. And I emphasise that the decision in question is that of the independent chair of RAVEC personally, not as officials, him personally. And he set out his experience very clearly in paragraph 3 of his first statement. I don't invite you to go back to it, it's in the supplemental bundle, page 35, paragraph 3 of Sir Richard's first statement. Extensive experience. Former chair of the Joint Intelligence Committee, permanent secretary of the Cabinet Office with responsibility for security, and by February 2020 he'd been chair of RAVEC for over a decade. This is a decision maker who knows how RAVEC works, who knows how security decision making within government works, who knows the merits and demerits of the RMD process, and what RAVEC will need to do inside and out, back to front. It's hard to imagine a decision maker more acutely familiar and better placed to form his own view as to what process will best enable RAVEC to take the decisions he's envisaging will be required in future in the context of the unique and unusual circumstances of the appellant. And the judge evidently and correctly took the same view. See the first sentence of paragraph 175. And as you will recall from the 2017 terms of reference, paragraphs 3 and 4, it is the chair who is responsible, and it is the chair who owns the risk, as it's put. In other words, it's the chair who is front-line responsible if RAVEC gets it wrong. All of those themes, all of those features, all of those factors have been reiterated time and time again at the highest level in our courts, including especially, and the court probably won't need to go back to this because I'm sure you're all very, very familiar with it, the Supreme Court Lord Reed in Bagan. Can I give you the paragraphs? I'm very happy to go back to them if you'd like to be reminded of them, but they are very familiar, I'm sure. The paragraphs that are key for present purposes, including the whole-scale adoption of what Lord Hoffman had to say about separation of powers, constitutional responsibilities, the reasons for respect, and all of that are paragraphs 55 to 62 in Begum. Paragraph 70, perhaps especially paragraph 70, and paragraph 109. And you find those in the authorities bundle, tab 22, page 878, then 882, then 894. And I emphasised that the predictive nature of the judgments involved was a feature in one of the reasons for according respect, alongside the deeper constitutional reasons for that. Can I just invite you to go back to Lord Carlisle, just to remind you of the sentence, sorry, of the paragraph that I think at one point my learned friend might have been going to refer to, and then decided belatedly that it was either not necessary or that she didn't need to, but I think you probably ought to see it if you can face it. Lord Carlisle, it's paragraph 32. I think she took you to some earlier paragraphs, but 32 is really the pull together of the earlier analysis, including his pretty much whole-scale adoption of what Lord Hoffman had said in Raymond, but he brings it together in paragraph 32 on page 513 of the authorities bundle. And again, I'm not going to read it out, it's quite a long paragraph. Can I invite you to read the whole of that sideline passage? So you see all of the themes: democratic accountability, institutional competence, as it's put, all things picked up by Lord Reid in passages I took you to, predictive assessment, no right or wrong answer in the sphere of security. So para 32 is the key paragraph in Lord Carlisle, and he returns at least to the predictive theme in paragraph 46, if you flip forward to that on page 521, making the point, amongst other points, that, as he put it, the future as a foreign country, as L.P. Hartley almost said. And again, you see how he applies the themes from 32 in that paragraph, bringing back those basic constitutional ideas and playing them through into the facts of the case that he was considering, which is a case about whether or not an Iranian lady should be admitted to the United Kingdom for the purpose of discussing things with parliamentarians. I emphasise, because my learned friend referred to, and I'm not quite sure what she was seeking to make of the Rwandan litigation, but she referred to it, but I emphasise that, as Lord Carlisle itself makes absolutely clear, because it was a case under the HRA about Article 10 rights, I emphasise the point that respect is to be accorded for all of the reasons that are identified by Lord Sumption and by Lord Reid in Begum subsequently, even in an HRA case. And I put it that way because, as we discussed earlier, under the Human Rights Act, and as the Rwandan cases in the Court of Appeal and the Supreme Court and Begum itself make clear, in the HRA context, the question of violation is for the court to determine. But there is no dissonance or discordance between that and according respect, because this according of respect, which is now absolutely constant as a theme throughout all of the recent Supreme Court case law, including in the context of Article 14, for example, in the recent SC case and so on. But it simply goes to how the court goes about determining that question for itself. And so that makes the point that even if the court is the ultimate judger, the ultimate determiner, the ultimate decision maker of, for example, good reason or violation of the convention, it matters not. There is a question as to how it goes about doing that. And the answer is, it goes about doing that by according proper respect to these sorts of judgments in this sort of context. It's also to be borne in mind that these points go, and they're pretty much flip sides of the same coin, they go to the breadth of the discretion that is accorded to a decision maker, but also to the degree to which the courts will scrutinise its exercise. And sometimes it's put in one way, sometimes it's put in another way. It doesn't terribly matter. But it is to be borne in mind that it applies to both of those things. And so the debates around rationality or how you take it into account and all of that don't depend upon how you describe it, whether you describe it as greater scrutiny or not. But we submit the judge made no error in according the degree of respect that he did to the issues in this case about what should be done in terms of process, particularly in relation to the R&D, which is the main thrust of the attack, in relation to the unique set of circumstances that confronted RAVEC here. And that takes me to the question, if good reason applies, what is the test? And we submit that the answer to that question is a question, as ever, of context. Perhaps it goes back again to my Lord breaking down the boxes. We're not locked into some equation as a matter of general principle between, for example, what might be a good reason and what might be a compelling reason, however expressed, whether you use the Lord Hope language or you don't, whether those adverbs apply or they don't. Necessary to appreciate that the description of the test is essentially a reflection of the respect due to the decision maker's judgments. In a context where high respect is to be accorded for all the reasons I've gone through as here, on all of the grounds I've indicated, the nature of what amounts to good reason is heavily influenced by their nuanced judgments to which respect has to be given. And what in truth my learned friend is doing by the constant repetition of the Lord Hope mantra is to narrow that without directly confronting its constitutional and principled underpinning. She seeks to narrow it by use of those language and that mantra without regard to the significance of their expertise in relation to this question. Of course, once one recognises that context is all and context will shape what the nature of the good reason that is required is, how intense the scrutiny is, however you want to put it, it becomes entirely unsurprising that there may be other contexts and other cases in which a more exacting standard is required, or in which a more a heavier good reason, I can put it that way, may be required. It's just a question of context. So the citation of Munjaz in the present context as authority for the need, as it were, for compelling reasons, whatever the phraseology was, incorrectly, we submit, elevates a fact and context sensitive decision into a generally applicable principle, and that is simply incorrect. Indeed, in Munjaz itself, the House of Lords squarely and directly recognised that the standard required of the reasons in question would vary according to context. See for that recognition para 21 of Lord Bingham and paragraph 74 of Lord Hope, authorities bundle, pages 192 for Lord Bingham and 209 for Lord Hope. And similarly, therefore, when the policy is one that is issued under statute and has the statutory framework, which may go to emphasise how thoroughly important it is that all national health authorities operate in the same way to achieve consistency, or all immigration officers dealing with a run of cases going through, again, to achieve consistency, approach it in a particular way. They're simply features that go to the context. You can't build from the assertion that strong reasons are required in one context to anything like a general proposition. That is therefore those two bits of this second aspect. Would you just give me a moment? I just want to check something on the wording, a sensitivity question on the wording. I put it this way because I'm very conscious this document may go to the press. In relation to this third question, this is good reason, application on the facts. Mm-hmm. Can you go to the summary document and go to paragraph 4? You see the final line says plans including. Mm-hmm. We're going, if we may, to delete the next 3 words.
Right. And
insert actual plans.
Yes. I'll do that on my copy.
Or just delete those words. We've already got actual plans. Yeah, we can just delete those 4 words if we may, and we'll make sure that when the press get it, it is in that form.
Fine.
So the basic submissions there. This addresses the question: was there good reason to dispense with an RMB assessment? We dealt with it in our skeleton 33 to 38. The judge carefully analysed both the contemporaneous evidence, which he'd gone through in enormous detail in the earlier part of the judgment, and the witness evidence. His analysis is principally on this issue at 166 to 173. And the upshot is that the good reason, as we submit it to be, is that the appellant's case and circumstances were sufficiently unique that the most appropriate way to take the protective security decisions in relation to him would be by using a bespoke process to consider the particular facts and circumstances applicable at the time. And we make the 4 submissions that I've set out or the 6 submissions that I've set out in the summary. The first of them is that it's critical to recognise the nature of the decision in question. Again, it's going to come as no surprise. As the Master of the Rolls noted, the decision was made in unique circumstances, where the appellant had stepped back from royal duties and decided to spend most of the time abroad. The question was what to do about that in terms of protective security. This was not, I emphasise, treated as a case in which RAVEC was no longer involved or didn't have jurisdiction in some way. It was considered with care. And the conclusion was, the February decision, which is what is being challenged, was that he would not continue to be treated on the same basis as before. They would not necessarily get all the protective security he had before, but that it was more appropriate not to make a once and for all decision, but to evaluate in the future, in the light of future situations, when he would be present in Great Britain, so as to assess the risks and so on then. And I emphasise also that nothing was excluded or shut down in relation to what might be useful or appropriate to do in the future, including, if considered useful or appropriate, which it might or might not be, to conduct some form of RMB assessment in the future. And it is the nature of the actual decision that frames the good reason analysis. In summary, good reason, question mark, for deciding that a bespoke process was appropriate. And the suggestion then has to be that an RMB exercise was necessary for that decision. So that's the first point, critical to understand the actual nature of the decision that's being justified, as it were. Secondly, the decision required consideration of a unique set of circumstances for which no provision had been made, even in the guidance provided in the terms of reference. That has, it is to be emphasised, not led RAVEC to throw up its hands in horror and say we haven't got any guidance under the TOR, so we're not going to make a decision. Still less to decide that the appellant fell outside its remit, as it were, so it didn't have to make a decision. But it also emphasises that there is nothing in the idea that the terms of reference governed or bound the process in some way, including RMB, in this sort of case, because there was simply no provision for this sort of case in the terms of reference. So if to the extent that my learned friend makes a submission that says, well, whether or not there's good reason depends on how hard you move from the policy guidance, we submit that you don't move very far from the policy guidance, and the policy guidance doesn't cater for the unusual set of circumstances that you're dealing with. That's the second point. Third point is that the evidence was considered with the greatest care and in considerable detail by the judge, who was, we submit, entitled to reach the conclusions that he did. And we do submit that it should not be forgotten. This is an appeal. The question is, was he entitled to reach the conclusions of fact that he did? Not whether there's some sort of re-argument and that you should do it all again. Obviously, if the thing has gone badly wrong in principle...
Well, unless you got the law wrong.
Unless you got the law wrong, exactly. We're back into that. But otherwise, it's the strict test that you know about in terms of disagreeing with the judge on findings of fact. Particularly, it might be thought, in a case like this, where there are very prolonged arguments, there was an enormous quantity of documentation.
Well, I mean, I'm interested in your submissions, Miss. The argument on the other side had quite a large proportion of this part of the judgment was wrong on the facts. So you say, do you, that short of an argument that those were perverse or simply wrong, could not be sustained, that was open to him unless he got the law wrong.
That's exactly what we say. Subject to the point we were discussing earlier, if you've gone badly wrong in principle, then the door gets open.
But this is not a perverse appeal. This is not an appeal of facts. This is an appeal
on the law.
On the law.
It is. Well, that's a submission. But for good measure, can I do the fourth and the fifth submissions together, as it were? Because then I want to develop them together, as it were. They are that the evidence indicated that the better and more appropriate course of action than calling for the RMB to produce some report was to consider the matter over time in the way that I've indicated, enabling consideration in the light of the actual facts and the actual plans and so on, and bringing to bear whatever expertise was necessary at that time. And not merely was that more appropriate, but that sort of bespoke consideration led and leads to no deficit for the appellant. And I wanted to develop those together, as it were. No deficit, we submit, from the nature of the bodies or their consideration of the issues, threat and vulnerability in particular. The makeup of the RMB is explained in Hitgrave 1, paragraph 56, supplemental bundle, page 92. The representation there, as I know my lords are aware, particularly from the question asked by my Lord Justice Bean, is very similar to that of RAVEC itself. There's a kind of overlap in terms of institutions. And of course, all of the expertise and so on is an institutional thing. It's not maybe enhanced by the thoroughgoing experience and expertise of a particular individual, but it's basically an institutional point. And so it makes a lot of difference if they are directly in effect the same organisations in different guises. the RMB is not more expert than RAVEC. The latter, of course, that's RAVEC, has very senior security and policing specialists and can call for whatever other expertise it considers as appropriate in a particular case. The RMB is not more independent in some way than RAVEC. There is no basis whatever for the suggestion that RMB would be more rigorous. On the contrary, the basis for the bespoke approach was that it had positive advantages from a security and risk assessment point of view, because you'd be doing it on the basis of an actual set of facts. The RMB's role as described in the evidence is concerned with an overview, taking a principal's position generally in the round. And that may be a very helpful exercise, as the evidence makes clear, when someone is here all the time and has got an established role or activities. It's a great deal less so when they're here for a limited time and for unknown or various purposes. But that is likely inherently to require a more flexible, more fact-specific approach. And that was at the heart of the judge's judgment at 170 to 174. And we submit he was entitled to make all of the factual findings that he did there. It is of some significance, we submit, that the chair of the RMB was himself intimately involved in the decision-making process and the run-up to the February decision by RAVEC. One can see that from the various exchanges in the email correspondence that the judge has assiduously set out in enormous detail, and then simply does the basic exercise of identifying from the paragraphs I'm about to give you in the judgment the extent to which there was communication about the thinking as it developed between and involving the chair of RAVEC and also the chair of the RMB. One sees it in particular from the judgment and its summary of the various exchanges and the conversations and emails, paras 25 to 28, 30, 40, and then especially the ones that you looked at yesterday, 54 to 58, in which the judge sets out those emails, the paragraph 1 emails, if I can put it that way. I think it was 207, 204 and the supplementary bundle. 54 to 58 of the judge's judgment sets those out verbatim, and he returns to that email exchange at 167 in the judgment. I know friend Miss Fatima says rightly that an RMB analysis may be qualitatively different from a threat assessment. So it is. It undertakes a risk analysis which takes the threat assessment as its starting point and goes on to consider vulnerability, generating in the lingo likelihood, and impact, generating in the lingo risk. But that is precisely what RAVEC did. Mottram 2, Mr. Richard Mottram's second statement, at paragraphs 24 and 32, supplemental bundle 151, expressly confirmed that the key steps in the normal process were fulfilled. I'm not going to go into the detail of all of that because it's confidential. I may have to come back to that in the confidential session, but I give you those paragraphs, 24 and 32 of Mottram 2. And I give you also, in that respect, the current RAVEC chair's statement in the supplemental bundle at page 358. Oh, I think you have the statement from the RAVEC chair you have had separately. Does that ring a bell?
Yes.
I suggest it may be better to put it at the end of the supplemental bundle. When you get there, can I invite you to go to, for this purpose, to 24 to 38 for the purpose of this point. And again, that's confidential, and I don't want to go through that now. So the point we draw from all of this is that the basis for the decision-making and the bespoke approach being adopted was that it had positive advantages from a security assessment point of view, not the least of which was that it would be focused on actual facts in the future. And I note again, it wasn't shutting down anything in relation to the consideration of future facts, including, as I say, it may well not be, but a consideration of whether or not an RMB analysis might be useful. And the view of the chair at the time, Sir Richard, was precisely that the bespoke approach was positively better for informed, protective security decisions than an RMB analysis. And indeed, all of the witness evidence, all of it, is to the same effect. You recall, just give you some references, you recall the level of experience of Sir Richard, Mottram 1, paragraph 3, I gave you the reference already, supplemental bundle, page 35, chair of RAVEC for over 10 years, intimately familiar with the processes and nature of RAVEC assessments and their context, as well as their suitability for the appellant's newly changed circumstances. See also in that respect the views of the current chair, paragraph 22. See also Sir Richard's first statement at paragraph 77, supplemental bundle page 57, mostly confidential, but ending with the words that the bespoke approach was, in his view, a flexible and tailored approach, better matched to the claimant's revised circumstances. He comes back to that in his second statement, paragraphs 35 to 37, supplemental bundle 154, especially paragraph 36, where he said the effect of that bespoke case-by-case consideration process would mean that an RMB would be unnecessary because alternative governance arrangements would be in place through RAVEC for considering individual requests on a case-by-case basis in context, and expressing the view at paragraph 37 that it made much more sense, as he put it, to do that for the confidential reasons that he gives in paragraph 37. And as he put it in 39 in that same statement, it was more appropriate and more useful to both RAVEC and the claimant to carry out the bespoke consideration of each request as and when it was required and in the particular context of the case. That's also the view, i.e. that that's the right way of doing this, of the current chair. See the witness statement of the current chair, paragraph 20, as he put it, and you ought to read the whole of that paragraph, but as he put it, a more effective and informed view could then be reached. It was the view of the senior Home Office official. See Hitgrave 2, paragraph 20. I just invite you to take that up, page 163 in the supplemental bundle. Can I, some of it's confidential as you will see, so I won't read it out. Can I invite you to cast an eye down paragraph 20? Setting out the detail as to why he concludes that it's would enable a better and more informed process, as he puts it. All of that is accepted by the judge, and we respectfully submit he was entitled to do so. See, for example, and in particular paragraphs 170, 172 and 173. And I emphasise, and I do it on the basis that this was a point that the judge was well alive to, see paragraphs 85 to 92, reflecting Mr. Hickgrave's evidence, 85 to 92 in the judgment. All of those witnesses well understood at all times what the RMB process was, what role it played, what it did, and how it did it, including, I might add, the chair of the RMB with whom the matter was discussed in the immediate run-up to the February decision. So the court at this level, and indeed the court below, would have had to have disagreed with the unanimous view of all concerned, with all of their expertise and experience, that this process was the most appropriate in terms of the process to be followed, that it was not necessary to hold any form of RMB process for the purpose of this decision, and that there was no deficit in the process they proposed to follow from the perspective of the appellant. He was not being singled out, as it was put yesterday. On the contrary, the process adopted had positive advantages for him in the view, the unanimous view of all of those witnesses. I wanted to pick up finally on this aspect, the point about weight. My first submission, you won't be surprised to hear me say, is that this isn't really a suitable subject for an appellate point, because precisely it is about weight, the matter for the judge. There's nothing perverse about his approach. The judge, this is about the ex post facto, does it correspond to the contemporaneous document, all of that. We submit that the judge was right, that the witness evidence was consistent with everything I've just described, and there was no reason not to accept that witness evidence in its totality, not least in the absence of any application to cross-examine those witnesses. See paragraph 177 of the judgment. And he directed himself, again correctly, by reference to Lord Burnett, the Chief Justice's dicta in the 2022 Good Law Project case. See for that purpose, for Lord Burnett's description of the principle, paragraph 86 of 2022 Good Law Project, Authorities Bundle 959, where he said the general rule is that the evidence of a witness is accepted, it's all in judicial review, is accepted unless given the opportunity to rebut the allegation made against them, or there is undisputed objective evidence inconsistent with that of the witness that cannot sensibly be explained away so that the witness's testimony is manifestly wrong. A court hearing a judicial review will generally accept the evidence of the public authority, and it will not normally decide contested issues of fact. The judge directed himself by reference to that approach in principle at 161 of his judgment here. But the position as I've described it and the reasons for it are reflected not merely in the witness evidence, but also in the contemporaneous documents, including, in particular, the email correspondence between the chairs of RAVEC and RMB, respectively, that you saw yesterday and that the judge recited and came back to in the reason part of his judgment at paragraph 161. There is no element we submit of ex post facto reasoning. This is a wholly orthodox elucidation of the context and the basis for the decision as taken at the time. That's an ordinary function of witness evidence in judicial review. And we submit that it is entirely consistent with the contemporaneous documentation. So you are nowhere near falling foul of the sort of circumstance which Lord Burnett identified as being the limited basis on which you could raise this sort of issue. So there's no error of law in the judge's approach, and there is no basis whatever to conclude that his factual conclusions were perverse or that he should have given different weight to the witness evidence, which appears to be the way in which it is, in brackets, impermissibly, close brackets, put by my learned friend. Finally on this, the within the cohort debate that my learned friend sought to raise by reference to Mottram 1, paragraph 14, we respectfully submit that that is a non-point. It's a non-point because at no point did anyone suggest that the appellant fell outside RAVEC's need to consider his case. They considered his case and they continue to consider his case. And as importantly, given that this is an appeal, the judge spent no time on that distinction. He did not find that the terms of reference didn't apply because the appellant fell outside them. Indeed, on the contrary, he assumed, correctly we submit, that they did apply, brackets, in his favour. Ground 2, to the extent that I can deal without an open, if that's acceptable to me. We haven't, I'm afraid, given you call submissions in summary form in the document on ground 2, but the reasons for that I hope will be relatively obvious. The essence of this ground, I'll try and describe it as faithfully as I can in open so that people can understand what it's about. But the essence of this ground is that RAVEC was required to, in effect, admit the appellant permanently into the cohort of those entitled to protective security at public expense, because his position could not rationally be distinguished from that of certain other individuals for whom RAVEC authorises that sort of protective security. The judge dealt with that supposed comparison, we submit, comprehensively and without error. See his judgment at paragraphs 181 to 191. But because this ground involves consideration not only of the appellant's protective security arrangements, which are themselves, for obvious reasons, confidential, but also that of certain others, it isn't possible to deal to any great extent in open court with that, and that's why we're going to have the private session. At a general level, it can be said in open session that RAVEC's approach is not to proceed by way of comparison in any event. And the judge correctly accepted that at paragraph 187. And that is for the obvious reason that it's highly unlikely that two cases will ever in truth be the same when judged against the broad guiding principles which apply. That's so not just because of the nature of the guiding principle and the absence of a hardline policy, but it's also because the concatenation of circumstances is likely to play differently in different cases, other than perhaps the clearest ones. It's also perhaps because the guiding principles that do apply and require a judgment or an assessment or an evaluation. It doesn't involve an empirical analysis of some description with a right or wrong answer, quite the opposite, for all the reasons I've given. And those features, we submit, lead to the position described in the evidence. The decisions by RAVEC are not made on a comparative basis or by seeking to analogize to others. See, for example, I don't invite you to turn it up now, see, for example, Hipgrave 1, paragraph 31, supplemental bundle, page 86, Hipgrave 2, paragraphs 12 to 13, supplemental bundle 161, the current chair's statement at paragraph 9, and Sir Richard's second statement at paragraph 8, supplemental bundle 146. So the approach involves an individual assessment in all of the circumstances of that particular case. What RAVEC considers are threat and impact factors are described in the guiding principles. No one, of course, I emphasise, is saying that comparisons may not, in principle, in some circumstances, be of interest, or, still less, that RAVEC was not aware of them, or did not, in fact, consider them on occasion. but nor is anyone saying that at a very high level, applying the guiding principles, they're designed to assess the protective security issues and so to distinguish inevitably between one case and the next. But it needs to be acknowledged squarely that it's extremely difficult and perhaps not very profitable to seek to compare cases other than through the broad guiding principles as applying across a range of similar cases. And I underscore the point that the helpful groupings by broad description, role-based, VIP, occasional and so on, are simply that. They're not, and they're not to be taken as hardline categories or an invitation to compare, still less the creation of some form of legal game of compare and contrast. One only has to consider the very different individuals within the other VIP category to see that the only real link between that group is that they don't fit readily anywhere else. There is, in short, no departure from the previous position taken or inconsistency in the evidence, simply a working through of that approach, and that we submit is plainly a lawful and legitimate approach in principle, and it was the approach applied by the judge to this set of issues. So, in conclusion then, we submit there is no proper basis for challenging the decision that bespoke assessment was appropriate. That was a position that RAVEC was entitled to take, a view that the chairman was entitled to reach. What mattered was the question of substance as to how they were going to deal with this unique set of circumstances. And to that issue, they brought to bear all of the expertise and experience that you're well aware of. So, my lords, those are my submissions in opening. I've come back particularly to ground 2 in the private session, the closed session, but I may also want to pick up a couple of other bits related to ground 1, including, for example, ground 1D. I'll come back to that if I may in private.
Have you got a revised timetable for from here on in? In other words, how long, Ms. Fatima, are you going to be in closed before you hand over to Sir James?
My lord, I'm hesitant to estimate because I don't know the questioning I'm going to get, but based on my notes, I think I should be able to do it in 45 minutes.
45 minutes. And then, Sir James, you're going to take your hour.
Well, my lord, I might do. If she's shorter, I'll try and be shorter. We'll
Try and be shorter if you can. Okay. So we can say, can we, then there's a reply, I think, in closed. A short reply in closed. So it should be an hour and a half, say, 2 hours max in closed. And it's now 12:15, let's say.
Yeah.
So we should be coming back at 3:15 into open, or 3:30, something like that.
Yes, there may, I don't know what my friend's positions will be, but I suspect that I shall be very, very, very short in that revised opening session.
Yes, okay. So that's for the benefit of everybody who is now going to leave. We will rise for a very short moment in order to allow the court to reassemble with only those who are allowed to be here in close. Thank you.
All right,